Today we're talking about what happens in a criminal trial during the prosecution's case. If you're involved in a criminal case in court and you've chosen to challenge or to contest the charges against you, the first stage of the trial will involve the start of the prosecution's case and the examination of their witnesses. The main purpose for this is for the prosecution to produce and present their own evidence that they feel supports and proves the allegations made against you and that show how you've committed the offence. At the trial, the charge is first read and explained to you before the judge will ask you whether you want to plead guilty or to claim trial to the preceded charges. If you want to claim trial, the prosecution will start presenting their case first. The prosecution can begin with an outline of its case and what it expects to establish through the trial. The examination of each prosecution witness consists of 3 stages. The first is the examination in chief, where the prosecuting officer will question their own witnesses so that the witnesses can give their oral evidence regarding the case and the facts. Second is the cross-examination, where you or your defense lawyer will question the prosecution's witnesses to challenge their evidence. And the third is re-examination, where the prosecuting officer will question their prosecution witnesses again, this time to clarify any issues that may have been brought up during the cross-examination. When a witness is on the stand, the rest of the witnesses must remain outside the courtroom, and you should ensure that your own witnesses are outside the courtroom as well. Generally speaking, your objective and the objective of your defense lawyer at this stage will be to ask questions during cross-examination to the prosecution's witnesses to get answers from them to show that their evidence against you is unreliable and should not be given weight by the judge. After the prosecution has called all their witnesses to testify, the court will then need to decide if the prosecution has presented enough of a case and enough evidence such that you must answer the charge. And you can make a submission of no case to answer at this stage if you feel that there is insufficient evidence to support the prosecution's case. If there is enough evidence to support the prosecution's case, the court will then ask you to present your own defense, and you'll be given 2 options by the judge. The first is you can personally testify and give evidence from the witness stand, or second, you can choose to remain silent and not give evidence in your own defense. If you choose to remain silent, the court can draw all reasonable inferences, including those that are not favorable to you, and the court can also take into account your silence when deciding whether or not you're guilty. For example, the court can infer that you have chosen to remain silent because you do not have any good or viable explanation or response to the allegations made against you. If the court has decided that there is some evidence that satisfies each and every element of the charges, and this evidence is not inherently incredible, meaning that the evidence is not blatantly far-fetched or impossible to believe, then you'll be required by law to answer and give your response and explanation to the charge. You have 2 choices at that point. First, if you choose to give evidence, then you must testify and speak in person from the witness box and be prepared to be cross-examined by the prosecution and also possibly asked questions by the judge. Second, if you choose not to give evidence in the witness box, meaning you choose to remain silent, then the court, in deciding whether or not you're guilty, is allowed to draw such inferences from your refusal to give evidence, including inferences that can be harmful to your credibility and defense. Whether you choose to give evidence or whether you choose to remain silent, you can always still call on other witnesses to give evidence in support of your own case. To recap, here's a quick summary of what you should remember about asking questions and conducting the cross-examination of the prosecution's witnesses. First, it's important that all the key evidence you want the judge to review is presented during your case. You must also focus your effort on telling the judge what happened in relation to the key incidents in question, meaning the issues and facts that are not relevant will not help the judge decide the case. Third, if you produce evidence to the court, you have to explain to the judge what the evidence is for and give details about how it was obtained and why it is reliable and believable. So, There you have it, some very basic information about what happens in a criminal trial during the prosecution's case. Thanks for watching.